Hello everyone, and welcome back to another episode of the Darrell saga. On today's video, we're gonna see the aftermath of the 15-minute rant. And I just want to apologize for the length of last video. I know it was an abnormally long video. I usually try to keep them to between half an hour to 45 minutes. But I wanted to get all that in so it didn't feel disjointed, if that's the correct word. But we're gonna see how the state and the judge react to this rant. But I just want to say thank you guys for watching. Thank you guys for hanging out. Thank you to the new subscribers that we have, for giving a like to the video, for hyping the video. I love to see the community grow, and I love to see us all enjoying together, which is what it's all about. Let's go into the video.
Mr. Brooks, I've given you about 50 minutes to make your various arguments. You've now repeated yourself a number of times, so I'm going to turn to the state to see if they have any response. Go ahead.
Thank you, Judge. Judge, I'm going to summarize what I just heard by quoting from a case from the Eastern District of Wisconsin, federal case found at 2022 Westlaw 3045190.
Can you repeat that last one?
I'm so sorry. 3045190. Retzloff versus Moran. This case is talking about many of the topics that Mr. Brooks has now recited to the court, and simply states the majority of Retzloff's filing is incomprehensible jargon and cut and paste legal mumbo jumbo.
That is a great way to describe it. Mumbo jumbo. I don't use that often. I don't hear that often, but that's so beautiful to hear. It's exactly what Darrell Brooks is doing. Copy paste mumbo jumbo.
Sovereign citizen theories are frivolous and wholly without merit. And the court goes on to cite to Bay, B-E-Y, versus the state of Indiana at 847, Fed 3rd, 559, on pages 559 through 560, a 7th Circuit Court of Appeals decision from 2017. Mr. Brooks knowingly
to being called that name, nor do I know any individual by that name, Your Honor.
Please do the courtesy of not interrupting the state, as they did not interrupt you for over the almost 50 minutes that you spoke. Thank you.
That is very fair, because Susan only talked for about 2 minutes before he had to object.
Please continue.
Your Honor, the record is very clear that Mr. Brooks knowingly, willingly, voluntarily, and intelligently insisted on representing himself in this trial. He has no constitutional right to stand by counsel, none whatsoever. The court patiently went through the form and advised him of many of the things he's complaining about here today: the resources of the state, the knowledge of the law, his ignorance of the law. And his words to this court, and I quote to the best of my ability, "It don't make me flinch one bit." That's
Oof, he regrets saying that now. He completely regrets. We have a saying here in Mexico, is that the fish dies because of his mouth. You know, it's a saying that means that if you talk too much, you mostly regret that. So it's better to just be quiet and do it. But yeah, his big mouth comes back to haunt him.
That's what he told this court, whatever it was, 2 weeks ago. Now he's here complaining over and over and over again how unfair this is to him. It's highly offensive. I don't know, because unfortunately I was talking to my investigator, if he accused this court of treason.
He did.
But I certainly heard that word come out of his mouth, and it is absolutely shocking that he would throw such a word around so loosely in this courtroom. This court has been exceedingly patient, exceedingly respectful of his rights at every turn. At every turn. I want to address this claim that he only had 3 days to prepare for trial. It's absolutely a false statement. The record should reflect that he does have 3 banker's boxes on his table. The record should reflect that every time the state calls a witness to the stand, he swiftly and easily turns to those boxes, which appear to be alphabetized or organized in some fashion by the public defenders who turned it over to him, and quickly removes the folder of the witness who's testifying and effectively cross-examines that witness using notes from the public defender. We know that because he's tried to confront witnesses with the notes from the public defender.
I love that she put that on the record. I love that she made it clear that Darrell Brooks is just using all the information that probably it had a point. Probably they made those notes because they had a strategy, but that doesn't mean to say word for word what they wrote. And he just copy pasting what other people did, just like with the sovereign citizen stuff, just with the law stuff. He has no mind of his own to come up with any of this.
He is not going into this blind or with one arm tied behind his back. They did all the homework, and he's simply sitting here reading their notes, reading their cross-examination questions, and asking the questions, and then going on to his ridiculous questions having to do with his belief in the sovereign citizen movement. There's no way this record would reflect that this defendant is not adequately prepared for trial. He's never asked for a speedy trial. He makes conflicting statements. On one hand, you violated his rights because it's taken us so long to get to trial. And on the other hand, we're rushing him to this case and he hasn't had adequate time to prepare.
Great point, Susan. This is why Susan is so great. This is why she was, because she's retired now. This is why she was such an asset to this estate. Because she's great. She catches on things. She doesn't let Darrell Brooks sneak away with anything. She's great because of it.
He is not denied access to legal materials in the jail. The record is very clear from the jail administrator. It should not be confused. He misleads this court intentionally to say, I only get out of my cell 2 hours a day. That is a fact. That is for his own safety, so that other inmates do not inflict physical harm upon him.
Which, if you are in the know of the day-to-day to Darrell, that has happened a lot. Like Darrell, now that he is in jail, he needs to be in solitary because he has a ton of stuff done to him. Like if you guys watch my coverage of his appeal when he fires his appeal attorney, he does this all the time. His hand is always above his mouth because he doesn't want people to know about his teeth. It's dangerous for him to be alone.
He has access to a tablet. He has access to a computer. Whether he chooses to ask for those resources is up to him. I would also cite the court to U.S. ex rel. George versus Lane, Lane, 7th Circuit Court of Appeals at 718 Fed 2nd 226, where a pro se defendant attempted to complain on appeal about his lack of access to a computerized legal research system, paralegal training, or law school education. The court rejected that contention and said, once a defendant has asserted his right to refuse counsel and conduct his own defense, he has no constitutional right to access those resources. And again, you warned him, Judge. You fairly warned him. And he basically acted as if you were insulting him and said it didn't make him flinch one bit. Much of the last 50 minutes, which this court has graciously extended him the opportunity to go on and on and on.
Also, what do you think the jury is thinking right now? Like, they're just wasting their time back then, and they don't have phones. They don't have access to any technology. So they're just staring at a wall, waiting for this to be over. Like, if I was the judge, or if I was someone in jail, I would put a TV with, I mean, no access to internet, of course, but I don't know, just a TV with a DVD of Friends. So every time that they go back to so they can pop one episode and they can get through the whole seasons, the 11 seasons of Friends.
Is nothing more than legal mumble jumble. He's reading from some typewritten transcript. I can see that from where I'm sitting. I don't know who's giving him these materials, but he has an agenda here. It's to stall, delay, disrupt, intimidate, and it's not going to work. Thank you.
Great job.
Objection to that. Your Honor, that's...
Shut up. It's my turn. Okay, so that was great for Susan. You can tell that she had this in her from this entire 6 days we've been on trial, that she wanted to get these words out. Of course, she's not going to do it out of nowhere because she's a professional. But now that she has the opportunity to express herself, she was able to call out Darrell Brooks on everything. All of his strategies, all of his shenanigans, everything was out in the open. And now he hates it because she discovered it, and he's going to deny it all.
That's a load of crap.
Mr. Brooks, that's my...
And using that word in open court is so disrespectful. I cannot expect more from him because he is Darrell Brooks, but don't use that language in front of people.
My opportunity now. I gave you about 50 minutes.
I just want to object to the disrespectful comments that was just made. I'm not trying to hold you up from what you're gonna say, but that's a load of crap.
Mr. Brooks,
for her to sit there,
Mr. Brooks,
for her to sit there,
objection is noted.
For her to sit there, Your Honor.
No, it's my turn. Let me go through this. I graciously gave you 50 minutes to raise all these various points that you want to bring up. I then gave the state an opportunity to respond. That is the proper procedure. I followed decorum. I followed civility. I did not interrupt you. The state did not interrupt you. Your objection to their characterization, it's noted for the record. I am going to render a decision at this point.
Give me 1 second.
Please listen.
Okay, I apologize for that because I thought my video was frozen. I thought that I did something wrong in the edit and that my video froze during all that. But if you see, let me take you back.
Point.
Look at that, he's
Please
frozen.
Listen.
I genuinely thought that my video was wrong, but he's just frozen in place. He doesn't move at all.
And please do not interrupt. As I indicated, the defendant spoke for about 50 minutes, raising a litany of complaints and issues and theories regarding his view of how this case has proceeded. Many of these issues, if not the vast majority or even all of them, have already been addressed by this court in one way or the other. Looking at, for example, his complaints about change of venue. It is true this court denied the change of venue motion. The court made a record at that hearing. I stand behind that record and that decision. The arguments made regarding that decision, which I would note he has yet to file an interlocutory appeal challenging that.
Yeah, he never files the appeal. He always thinks that because he just says it on court, he's people are gonna do the work for him. He never files the appeal. He always has asked for the opportunity to present it, but he never files it.
Are nothing more than speculative, without a basis in law or fact. To say that this jury is biased would be a complete miscarriage of justice and a mischaracterization of the process this court painstakingly took in order to obtain a fair and impartial jury. There is absolutely nothing on this record before the court throughout these proceedings to suggest that this is a biased jury. I stand behind my previous determination and the process that this court went through, including initially calling an unusually large panel for which the clerk of court's office sent the initial qualification questionnaire, and then ultimately a case-specific questionnaire was sent to approximately 1,400 jurors or potential jurors. There was ample opportunity for the parties throughout the proceedings leading up to the end of August to review those materials. There were numerous strikes for cause that this court entertained. Even prior to that specific hearing, the parties met, they conferred. The state agreed not to challenge the vast majority of the challenges to jurors brought by the defense. Then there was the hearing. Then this court, at jury selection, allowed for an indefinite number of strikes for cause. Many were granted, if not all. And then
Infinite. He could have removed any juror that he wanted, and they will probably would have said yes. It's his own fault that the people on the stand are there. So if he didn't want, I don't know, any of them, if he didn't want any of them, they could not be there. So stop complaining about that.
even on the day that the jurors were brought in, the court provided the jurors with a supplemental questionnaire dealing specifically with the issue of exposure to the political advertisements. And then each party had the opportunity to exercise 10 preemptory strikes, which is well above the number of strikes allowed for by statute, which would be 6 based upon the homicide charges, 1 extra for the alternates, which would be 7. But out of an abundance of caution and in the interest of justice, the court gave each side 10, for which many of those Mr. Brooks chose not to exercise. And then pursuant to state law, the clerk of court chose names to strike by lot. Again, there's nothing on this record before the court to suggest that this jury that we have is anything but fair and impartial. And I take issue with the characterization that they are anything but. They've been diligent, they take notes, they are attentive, they come to this court as the case law says there's a presumption that they come to the court without bias, and it's through the jury selection process that the parties and the court ferret out that bias. Many of the jurors who were brought in were struck for cause. Many others were not. But ultimately, we have a fair and impartial jury.
And also, the people in Waukesha, from what I've seen in the trial, every witness, every law enforcement officer has been at the light. I have no bad things to say about anyone from Waukesha that I've seen. And I got some people in the comments who are also close to Wisconsin, and they've been in Waukesha, that can corroborate this. So I will not hear someone speak ill of the Waukesha community.
As I listen to the litany of issues and arguments and complaints raised by Mr. Brooks, I would note that they are all unsubstantiated, conclusory allegations and assertions without an adequate basis raised in law and fact. There's been several misstatements by Mr. Brooks regarding either the record that's been made, items that's been provided to him, or the basis for the court either sustaining, I should say, or
Notice the little slip ups that she got from hearing Darrell Brooks keep saying sustain. He's so evil that even language, he damages language.
overruling objections, for an example. There's been a mischaracterization of his rights that he claims to have. As I have stated repeatedly, your constitutional rights are not absolute when you're in a criminal trial, meaning your First Amendment right is not unfettered. It is frankly no different why the case law is very clear. You can't yell fire in a crowded theater. No one has a First Amendment right to do that. In a criminal case, the parties have an obligation to follow not only the Constitution and the statutes that are applicable, but to follow criminal procedure, the rules of evidence. That is what circumscribes the rights that a defendant or the state has in a criminal trial. The issues you raise, for example, regarding subject matter jurisdiction are baseless, they're frivolous, and they're not anything this court needs to address further. The fact that you now are asking questions about whether this is admiralty court or a military court or a court of competent jurisdiction is frivolous. This court has jurisdiction over the criminal cases brought before it by the state of Wisconsin. In this particular case, these are allegations that criminal conduct occurred in the city of Waukesha. The city of Waukesha is within the county of Waukesha. This court sits as an elected official in the county of Waukesha to hear these types of cases. That is clear.
I love that. I love that she even put emphasis that she was elected to be there. That she is the authority. I mean, there are some other judges, right? But in this case, she's the authority in Waukesha. If something happens that is criminal in Waukesha, she takes care of it.
The only argument or relief that I could discern through the course of those 50 minutes was Mr. Brooks's request that this case be dismissed for lack of subject matter jurisdiction. And as I have just indicated, this court has jurisdiction. It's not been raised. Let me rephrase that. The issue has not even been raised properly. There's never been a written motion. There's never been even an oral motion that would comport with 80201, which requires that the basis for the relief being requested be stated with specificity and be based in law and fact.
Something that he never does. He never presents a proper motion with all the requirements. The fact that he keeps bringing papers that he believes that because they accept them, that they are valid, is not. They have to accept every single thing that you pass to them because it's part of the record. You did it. But that doesn't mean that it's something official that they have to respond to.
The vast majority of the points that you raise, sir, are issues that you can raise on appeal. It is true, you have a right to an interlocutory appeal. I would not be the judge to decide any of those issues. So the fact that you complain about what I do, it's noted, the record is going to be very clear. All right? I have a court reporter who's taking down the record of everything that is said and done in this courtroom when we are on the record. And so I don't have to all the time say it's noted for the record because we're on the record. I sometimes do that to hopefully make it clear to you or to note it. I don't always do that, but I'm not required to do that. You raise issues concerning, I guess, plea bargaining. I have never been made aware that you would want to change your plea in this case, and that you're not aware of the state wanting to do that. That is the first time any such issue has been raised, and I see it as a distraction and as simply a statement made by you as part of the litany of things that you are not perhaps pleased with. As far as my conduct in this case, I already addressed those issues. I'm not going to revisit issues related to my familiarity with the father of one of the victims. That was done very early on. I made a very thorough record, and I gave the parties at that point an opportunity to address that after they had ample time to digest that information. While it's true you have a right to seek substitution of judge, it is not unfettered. There was a time limit for that. In fact, it was exercised because a prior judge was assigned to this case, and your attorneys on your behalf exercised that right of substitution.
Yeah, he was so close of not getting Judge Doro. He was this close, but they decided that the prior judge was going to be even worse for Darrell Brooks. So he got a better deal, and even then they threw the book at him.
So to say that you have the right to seek recusal at any time would be a misstatement of the law. And even if you think that should be exercised or there is a valid claim for that, sir, it's not been raised in the proper way before this court. This trial will keep going. I still expect the basic rules of civility and decorum to be followed. That includes, sir, that when there is an objection to a question that you ask, that you wait for the state to indicate their objection and the basis for it. If
you guys think that he's gonna do that? You guys think that at this point he's gonna change? He hasn't changed in 40 years. He's not gonna start now.
I need additional information, I will ask for it. If I don't need additional information, I will rule on it. And I do expect that even if you disagree with that ruling, that you will abide by it and that you will move forward. Whether that's asking a new question, rephrasing a question that you've asked, I do ask that you follow that simple rule of decorum. And that's you not interrupt, and then you follow the rules of procedure. As far as the other issues you raise concerning your right to assistance of counsel, the record before this court, over the many days that that topic has been raised, even going back to the 2 afternoons of hearings this court held, I will not revisit those. I believe I honored your request to represent yourself as is required by the Constitution of not only the United States of America, but the Constitution of the state of Wisconsin. And that you made a very deliberate choice after being fully advised and aware of all the requirements that I needed to go through under the case law, both case law in the state of Wisconsin and case law from the 7th Circuit Court of Appeals, which not only guides this court, but this court must follow.
And so far, he's been quiet because he was asked to, because this is an important part of the topic, but she has rebutted in 10 minutes what he's been rambling on and on and on for an hour, which is quite remarkable.
I agree with the state and would draw your attention to the 2 cases that were cited. United States ex rel. George versus Lane, found at 718 F. 2nd 226, and Retzlaff versus Moran, found at 2022 Westlaw 3045190. I let you put on the record all of those points in order to give you that opportunity to make a full record of the issues that you have believed that you are entitled to raise. But those sovereign arguments regarding written findings of fact, bill of particulars, regarding contracts that you enter into, regarding admiralty court, etc., they're baseless, sir. And this court need not address them further. Now, with that, I know it's 11:30, but I would like to get one more witness on before at least we break for lunch. The jury, of course, has been out for quite some time. So I'll instruct Madam Clerk to bring the jury out.
For the record, Your Honor, you didn't bring up the Higgins-Levine 415 U.S. 533 decision. That was not addressed, and the issues are still not addressed. There's still been no proof to anything that you said, anything that the prosecution has said.
But they don't need proof. They know it's right. And the state and the United States of America backs them up. So unless you live in another place, which I don't think you are, it's not right.
Still hasn't been.
As noted, and we will continue. Bring the jury out, please.
There still hasn't been
Mr. Brooks,
any proof.
I've addressed them to the extent that I will.
There still hasn't been any proof. I never once. The comment about me not flinching was when you said that there's 66 years of experience at that table. That's the comment I said, that doesn't make me flinch. That was mischaracterized. That should be for the record. There's still been no proof.
Mr. Brooks, please stop. I'm not going to address whether there's verified proof or not of jurisdiction, whether there's anything along those lines. It is frankly not required under the law. You may disagree with that. You can take that up on appeal, whether that's an interlocutory appeal or whether that's a direct appeal if there is a conviction. But I'm not going to address it any further.
Because there's no verified proof.
There does not need to be, sir. All right, I believe the jury is coming.
Very powerful there. It does not need to be. They have jurisdiction. She has explained why they have jurisdiction, and you are standing before her. So what more do you need to understand that?
Coming out, is that true?
In order for a case to...
All right, the record should reflect that the jury is coming out, and we are about to continue with the state's next witness.
Once was the plaintiff addressed. That wasn't addressed. Where's the plaintiff? Where's the injured party? That's because
the jury will disregard the statements presently being made by the defendant.
Because y'all don't want the jury to know the truth.
The jury will disregard those statements made by the defendant.
I see.
It is not his opportunity to testify. They are comments, and as such are to be disregarded.
I see what's going on.
He sees what's going on.
Ain't gonna work.
All right. Thank you, everyone. You may be seated.
All right. Let's see if it doesn't work, Brooks. All right. Thank you guys for watching. That was a powerful moment. Let me know in the comments if you think that Darrell Brooks is going to behave from now on, because we still have a ton of witnesses to go through, and he's gonna keep doing cross-examinations. But for now, thank you guys for watching. I'll see you on the next one, and remember that you're great, that you matter, and that I'm really happy that you guys are here. I'll see you on the next one. Bye-bye.